6 justices, 3 dissenters, one decision that just sent shockwaves through concealed carry laws across every single state in this country. And here is the hard truth. Most news outlets are completely missing. They are telling you this is about one state. It is not. This is about your permit, your state, and what you can legally do the next time you walk out your front door with a firearm on your belt. I've spent the last several hours going line by line through the full majority opinion, the dissenting arguments, and cross-referencing everything against state-level statutes so you do not have to. What I'm about to break down could literally determine whether you are exercising a constitutional right or committing a felony the next time you walk into a grocery store or a shopping mall. So stay with me, because this one matters. Here is what just happened. The Supreme Court of the United States released a 6-3 opinion in a major Second Amendment case. And if you are a concealed carry permit holder, this ruling just put a massive target on state laws that were specifically designed to nullify your rights after the 2022 Bruen decision. For those who need a quick refresher, New York State Rifle and Pistol Association versus Bruen struck down what are called may-issue permitting schemes. It said, states cannot force you to prove a special need to carry a firearm. But as we have covered before, states fought back hard. They could not say no to your permit outright, so they said no to where you could take it. They created enormous lists of so-called sensitive places. Subways, parks, restaurants, private businesses open to the public. Basically, they tried to shrink your constitutional right down to almost nothing. A permit in theory, useless in practice. Today, the Supreme Court said enough, said, "The majority opinion makes one thing crystal clear. The Second Amendment follows you onto private property that is open to the public unless there is a specific, well-established historical tradition of banning firearms in that exact type of location." And here's the part that has legal analysts genuinely scrambling. The court ruled that general private property open to the public cannot be broadly designated as a sensitive place by the state. Think carefully about what that means. It means state legislatures cannot pass a blanket law saying no guns in any business. It means the default rule is now carry unless the individual property owner decides otherwise. The state cannot make that decision for them. This completely flips the script on every expansive sensitive place law passed since 2022. Now, I know what some of you are thinking. Did we not already know this? No. You did not. And here is exactly why this is a shock. Leading up to this decision, many legal scholars predicted the court would punt. There was a genuine and serious fear that the justices would carve out a massive exception for private businesses, effectively allowing states to ban carry in 80% of daily public life by leaning on private property law. That would have been devastating. It did not happen. Instead, the court drew a hard constitutional line. They distinguished between property that is truly private, like your home, and private property that functions as a public square, like a shopping center or a restaurant. When a business opens its doors to the public, it steps into a space where constitutional rights apply differently. And the state cannot impose a blanket firearms ban on those premises without pointing to a meaningful historical tradition that supports it. Let me take a step back and give you the full context, because this ruling does not exist in isolation. Back in 2022, Bruen created a new constitutional standard. If a gun regulation restricts conduct covered by the plain text of the Second Amendment, the government must demonstrate that the restriction is consistent with America's historical tradition of firearm regulation. Not interest balancing, not public safety arguments, not we think this is a reasonable policy. History and tradition. That framework immediately put dozens of state laws under enormous pressure. But here is what many people missed at the time. Bruen did not answer every question. It settled the May issue fight and established the standard. But it left wide open battles over sensitive places, private property rules, training requirements, insurance mandates, and location-based carry bans. And states moved fast to exploit those gaps. Some legislatures responded to Bruen by expanding their lists of prohibited locations so aggressively that your permit became nearly worthless in daily life. Restaurants that serve alcohol, public transit, parks, entertainment venues, entire commercial districts. In some jurisdictions, you technically had a permit, but there was almost nowhere in your daily routine where you could actually exercise it. That strategy set the stage for what just happened. This new ruling zeroes in directly on those post-Bruen restrictions, and it asks a very direct question. Can a state effectively nullify your right to carry by declaring broad categories of everyday locations off limits? And in a sharply worded majority opinion, the answer was no, not without solid historical evidence to justify each restriction. The majority reaffirmed that the Second Amendment covers carrying firearms in public for self-defense. That part was already settled. But the court went further by emphasizing that states cannot invent sweeping gun-free zones unless they can point to a well-established tradition of similar restrictions from the founding era. That is where the shock wave originates. because during oral arguments, multiple justices openly questioned whether modern location-based bans had any meaningful historical analogues whatsoever. The ruling analyzed founding-era regulations and concluded that while certain locations, like courthouses and legislative assemblies, do have long-standing historical prohibitions, broad commercial districts and ordinary public gathering spaces simply do not share that pedigree. You cannot turn half a city into a gun-free zone and call it consistent with American history. The three dissenters argued the ruling would destabilize public safety frameworks in major metropolitan areas. But the majority rejected that framing entirely and reiterated a principle that is going to be quoted in lower court opinions for years. Constitutional rights do not shrink simply because a state finds them inconvenient. Now let me be very direct with you before we go further. This video is educational information based on publicly available court decisions and legal analysis. It is not legal advice for your specific situation. Firearm laws vary by state, and they are changing fast. Before you make any decisions about where and how you carry, speak with a licensed firearms attorney in your jurisdiction. What we are doing here is analyzing the constitutional landscape so you understand what the terrain looks like. That understanding is power, but it is not a substitute for professional legal guidance. With that said, let us talk about what is actually under pressure right now. The court did not say you can carry everywhere. That is a straw man argument, and it is important we do not fall into that trap. There is a narrow category of sensitive places where restrictions can still stand. The majority was clear about what survives. Schools and educational facilities have historical support from the founding era. Courthouses and courtrooms carry a deep tradition tied to maintaining order in judicial proceedings. Polling places have historical analogues related to preventing armed intimidation during elections. Government buildings with secure screening, like federal offices and Capitol buildings, remain protected as well. Notice what is not on that list. Restaurants, shopping malls, grocery stores, public parks, transit systems, private businesses that simply serve the public. The court was pointed in its reasoning here. Just because a place is public-facing does not automatically make it sensitive under the Second Amendment. States cannot simply label a location sensitive and call it a day. They must do the historical homework, and most of them have not. So what does this look like practically on the ground? Imagine you live in a state that responded to Bruin by banning concealed carry in shopping centers, restaurants, theaters, public transportation, and any private property open to the public unless the owner gave explicit permission. Under this new ruling, those sweeping restrictions are now constitutionally vulnerable. The burden of proof has shifted. It is no longer on you to prove you have a right to be there. It is on the state to prove why that specific location has a historical tradition of firearms prohibition. That is a monumental change. But, and this is critical, it does not mean those restrictions are automatically gone tomorrow. This is the part nobody is fully processing yet. Supreme Court decisions filter downward through the court system. They do not instantly rewrite state codes overnight. Laws remain on the books and remain enforceable until a court formally blocks or strikes them down. That means we are entering a transitional period right now, a period where laws may be vulnerable but still technically active, a period where enforcement policies will be inconsistent, a period where confusion will spread among permit holders and law enforcement alike. Here is the likely sequence of events. First, active lawsuits challenging location-based bans will immediately cite this new ruling. Plaintiffs will argue their cases are now directly controlled by the Supreme Court's clarified standard. Second, district courts will begin issuing injunctions, potentially blocking enforcement of specific restrictions while those cases work their way through the system. Third, and this is crucial, states will not simply accept defeat. They will attempt narrower rewrites. Instead of banning carry in all restaurants, a state might limit the prohibition to establishments that are primarily engaged in alcohol service. Instead of banning carry in all parks, they may try to narrow it to specific event areas. The fight will shift from broad categories to granular distinctions, and during that entire period, confusion is inevitable. We are already seeing attorneys general in several states issue statements saying they are reviewing the opinion and evaluating next steps. Translation: they are looking for ways to delay, narrow, or work around this ruling without technically defying it. Three specific tactics are already emerging. First, signage laws, where states shift the burden onto property owners and require no gun signs to be posted everywhere, creating a patchwork where carry is legal unless a sign says otherwise. Second, redefining what qualifies as sensitive by arguing that entertainment venues or public gathering spaces fit the historical doctrine. Expect heavy litigation on exactly this question. Third, filing motions to stay the effect of the ruling, claiming that immediate implementation would cause public safety disruption. It is also worth understanding that lower courts are not a monolith. The Ninth Circuit, covering states like California and Hawaii, has historically been far more deferential to firearm regulations. The Fourth Circuit, covering Maryland and Virginia, has shown mixed signals over recent years. The Second Circuit, which includes New York, has been actively wrestling with post-Bruen cases since 2022. With this new ruling now on the books, all of those courts have stronger, clearer guidance and significantly less room to maneuver. When a majority opinion is this pointed and concrete about limiting sensitive place designations, it signals to every appellate court in the country that this is not a narrow or factional view. This is the controlling constitutional standard. And if lower courts interpret that broadly, sweeping location bans could begin falling rapidly through injunctions within months. If they interpret it narrowly, some restrictions survive for years while litigation drags on circuit by circuit. Either way, this is a multi-year process, not a single moment of resolution. This is why you cannot simply assume the law changed this week in your state. The constitutional principle has shifted decisively, but on-the-ground enforcement will lag, and that gap is exactly where mistakes happen and where good people end up in serious legal trouble. So here's what you should actually do right now. Not tomorrow, now. First, audit your state's current prohibited locations list. Go to your state's official website or a trusted legal resource. Find the current concealed carry statute and the specific list of prohibited locations. Write it down. Keep a physical copy. Do not rely on memory, and do not rely on what someone told you in a comment section. Compare that list against what the court actually said. Any location that is banned solely because it is private property open to the public is now legally vulnerable. Note those locations carefully. Do not treat them as automatically legal tomorrow, but understand the constitutional ground has shifted beneath them. Second, identify a firearms attorney in your state before you need one. Do not wait until you are in trouble to find legal representation. Search for a licensed attorney who specializes in Second Amendment law or firearms defense. Save their contact information in your phone right now. Many offer free initial consultations. Use that. Build that relationship during a calm moment, not in a crisis. If you are ever stopped or charged in a location that was previously banned but may now be legally questionable, you want someone on the phone immediately who understands the historical test, understands your state's specific statutes, and understands how local courts are interpreting the new standard. Third, consider joining a legal defense organization that is actively litigating cases in this space. Groups like the Firearms Policy Coalition and the Second Amendment Foundation are already working on cases built around this new ruling. Your involvement helps fund the next legal battle. And in some cases, these organizations may provide legal support if you become a test case. This is how constitutional change actually becomes lived reality, not through headlines, through coordinated, strategic, well-funded litigation. Now, there is also the question of how to handle yourself if you are stopped by law enforcement in a location that was previously banned under state law but is now constitutionally questionable under the new ruling. This is not a hypothetical. It is going to happen to real permit holders during this transition window. The answer is not to argue constitutional law on the side of the road. It is to stay calm, keep your hands visible, follow all lawful commands, and clearly but respectfully state that you are legally exercising your rights under current Supreme Court precedent. Do not escalate. Do not lecture. Do not argue. Everything that matters in that moment can be resolved later through proper legal channels with an attorney by your side. The street is not the courtroom. Preserve your rights for where they can actually be protected. And here is one more practical step that almost nobody talks about. Prepare a one-page reference document and keep it with your permit at all times. On that page, write the case name and decision date. Write the core holding in plain language. List the locations the court confirmed are still valid sensitive places. Note that blanket bans on restaurants, shopping centers, parks, and similar everyday venues are now presumptively unconstitutional. And include the URL to the full opinion on supremecourt.gov. Why? Because in the next several months, you may encounter a law enforcement officer who has not been briefed on this ruling. You may be in a jurisdiction where local officials are actively resisting the decision. That document allows you to politely reference the Supreme Court's holding without arguing, without escalating, and without relying on memory under pressure. It is not a legal shield, but it is a tool for calm, informed dialogue. Now let us zoom out and look at the bigger picture, because what just happened is not simply another court opinion. It is the next stage in a chain reaction that began with Bruen and is now accelerating. The conservative majority, including Chief Justice John Roberts and Justices Clarence Thomas, Samuel Alito, Neil Gorsuch, Brett Kavanaugh, and Amy Coney Barrett, has now repeatedly reinforced one foundational principle. The Second Amendment is not a second-class right. That language is deliberate. It signals parity with every other constitutional protection. Imagine if a state declared most public sidewalks off-limits for free speech without historical justification, or required founding-era analogues before permitting religious assembly in common spaces. The court would demand extraordinary justification. That same level of scrutiny is now being applied to concealed carry location bans. And that shift is structural, not temporary. It means every time a legislature drafts a new firearm restriction going forward, the first question must be, where is the historical analog? If there is not a convincing answer, the regulation is constitutionally vulnerable from the moment it is signed. That creates a long-term ripple effect far beyond concealed carry. Training mandates, insurance requirements, age-based restrictions, firearm storage laws, all of these areas will continue to be litigated under the same historical framework. We are watching a doctrinal realignment that will likely define Second Amendment law for the next generation. Some gun owners are treating this as a total and immediate victory. Some gun control advocates are calling it dangerous and destabilizing. The truth, as usual, is more nuanced than either reaction. This ruling does not eliminate all gun-free zones. Courthouses, legislative assemblies, and historically grounded sensitive locations remain protected, and the court acknowledged that explicitly. What the ruling rejects is the strategy of redefining vast swaths of everyday American life as sensitive without any historical grounding to support it. That distinction is everything. Constitutional rights evolve through litigation. They expand, they contract, they stabilize, but they rarely move in a straight line. What we are seeing right now is momentum, not finality. The legal terrain is actively shifting beneath our feet, and concealed carry holders who stay informed and stay prepared will be in a fundamentally different position than those who rely on headlines and assumptions. So stay disciplined, stay legally compliant while the dust settles. Track the court challenges unfolding in your circuit. Know exactly what the law says in your state today, not what you hope it says, and build your legal support network before you ever need it. Because in a period of legal transition like this one, clarity is not just useful, it is your most important form of protection. Everything covered here is educational content based on publicly available court decisions and legal reporting. Nothing in this video is legal advice for your specific situation. Gun laws differ in every state, and they are changing rapidly. Before making any decisions about where and how you carry, consult a licensed firearms attorney in your state. That is the only person who can give you guidance that actually applies to your exact circumstances. Stay informed. Stay protected.